Welcome to Law and Society. Today I'm going to go over the Supreme Court's decision that has allowed Donald Trump to remain on the presidential ballots. SCOTUS did not reach the merits of the case, holding that states cannot unilaterally disqualify candidates for federal office, especially the presidency. So if you're new to my channel, please like and subscribe, and let's dive into it. The court's ruling was exact opposite of what I wanted and wished the court would do. And at the end of my previous episode talking about disqualification, I mentioned at the very end that either the court would follow the states' rights way or it would go about the Griffin's way and the enforcement clause. And that's exactly what they did. They went with the Griffin's case and with the enforcement clause. And it's this court is not a it's a radical court. It departs from originalism and textualism and conservatism and restraint, judicial restraint, whenever it wants to. It overreaches and brings back precedents that are not binding and then moves on and connects it with the enforcement clause and creates precedent by becoming what could be called as a super legislature as opposed to a judiciary. So here, the Supreme Court has done what a conservative Supreme Court wouldn't do, is go well beyond the question that has been asked, and sort of uh, provide a decisive answer, but yet still encroach on a state's rights and the the fact that states have power under Article 2 of the 12th Amendment. Also, one very important thing: this court did not go into the merits of the case. It did not go into whether or not Donald Trump engaged in insurrection, whether or not that disqualifies him. It didn't do the factual finding, or it didn't even go over the factual finding. It doesn't. Supreme Court doesn't do factual findings, but it didn't even go over and bring it up in their opinion, not once. It's not. It's whether or not this person in this case engaged in insurrection was never sort of asked and answered in this ruling. So what I will do is now, as I have done before with important cases, is go over the ruling and then pepper it with a few comments as we go. The Supreme Court says we granted former President Trump's petition for certiorari, which raised a single question: did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Concluding that it did not, concluding that it did, we now reverse. So I think it's important for me to point out that the majority of the Supreme Court writes, it sort of switches between former president and President Trump. So I'm not really sure whether they did that out of just chance, or whether they they are giving Donald Trump more respect than they deserve. Moving on. Proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment expanded federal power at the expense of state autonomy and thus fundamentally altered the balance of state and federal power struck by the Constitution. And Section 5 confers on Congress power to enforce those prohibitions, along with other provisions of the amendment, by appropriate legislation. Section 3 of the amendment likewise restricts state autonomy, but through different means. It was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. Section 3 aimed to prevent such resurgence by barring from office those who, having once taken an oath to support the Constitution of the United States, afterward went into rebellion against the government of the United States. Section 3 works by imposing on certain individuals a preventative and severe remedy, disqualification from holding a wide area of offices, rather than by granting rights to all. So here, the court is sort of, you know, showing the difference between the disqualification clause and Section 1 of the 14th Amendment, where it vests rights as opposed to here, it's a punishment that it takes it away. It is therefore necessary, as Chief Justice Chase concluded and Colorado Supreme Court itself recognized, to ascertain what particular individuals are embraced by the provision. So now it's quoting the Griffin's case, which is a non-precedential case, and the argument for enforcement that comes out of that case. The Constitution empowers Congress to prescribe how those determinations should be made. The relevant provision is Section 5, which enables Congress, subject to course of judicial review, to pass appropriate legislation to enforce the 14th Amendment. Or, as Senator Howard put it at the time of the amendment was framed, Section 5 casts upon Congress the responsibility of seeing to it for the future that all sections of the amendment are carried out in good faith. Nothing to say about the self-executing nature of the of Section 1 of the 14th Amendment. Then the court says Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation, less than a year after ratification, Senator Trumbull noted that, notwithstanding Section 3, hundreds of men were holding office in violation of its terms. The Constitution, Trumbull noted, provides no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. The enforcement mechanism Trumbull championed was later enacted as part of the Enforcement Act of 1870, pursuant to the power conferred by Section 5 of the 14th Amendment. So here it's talking about the Enforcement Clause of 1870, which, by the way, was repealed in 1948. So what remains in the books now is 18 U.S.C. 2383, and that doesn't really go all the way because it takes away the Congress's power to remove the disability. So, here the necessity for an enforcement clause was brought up when this amendment was ratified. That's what the court is trying to say. Section B, then the court goes into, this case raises the question whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. So here, the Supreme Court makes a distinction that the amendment itself doesn't. It doesn't forbid states from disqualifying. And in this paragraph, the Supreme Court itself concedes that, states may disqualify state officers, but the amendment itself made no distinction of who could disqualify state and federal officers. So there's a disparity over there. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from states that traditional authority. After ratification of the 14th Amendment, states use this authority to disqualify state officers in accordance with state statutes. Such power over governance, however, does not extend to federal office holders and candidates. Because federal officers owe their existence and functions to the united voice of the whole, not of a portion of the people. The powers over their election and qualifications must be specifically delegated to rather than reserved by the states. So here is U.S. term limits is a judicial precedent that talks about uh, talking about how the election of federal officers uh, it it talks to the whole country as opposed to a section of the country, and so um, and powers over their elections must be specifically delegated, means through law, congressional law, rather than reserved by the states, as it would happen had it not been congressionally legislated. Which, interestingly, in this case, it wasn't congressionally legislated. Yet the court says it has to be congressionally legislated. Um, um, what do you do in the absence of it? Then you come to this court, and this is what the court says. It's circuitous, but nothing in the Constitution delegates to states any power to enforce Section 3 against federal office holders and candidates. But the text of the 14th Amendment on its face does not affirmatively delegate any such power to states. The terms of the amendment speak only of the enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. So, nowhere, by the way, in the amendment does it say the state shall not enforce Section 3. It doesn't say that. But the general argument of the court is that the 14th Amendment was intended to take power away from the states. So vesting this power over federal office to states is incompatible. Under the amendment, states cannot abridge privileges or immunities, deprive persons of life, liberty, or property without due process, deny equal protection, or deny male inhabitants the right to vote without thereby suffering reduced representation in the House. On the other hand, the 14th Amendment grants new power to Congress to enforce the provisions of the amendment against the states. It would be incongruous to read this particular amendment as granting the states power, silently no less, to disqualify a candidate for federal office. So that's where, what I was just talking about, and that's how the court answers that question. The only other plausible constitutional sources of such a delegation are the elections and electors clauses, which authorize states to conduct and regulate congressional and presidential elections respectively. That's Article 1, Section 4, Clause 1, and Article 2, Section 1, Clause 2. But there is little reason to think that these clauses implicitly authorize the states to enforce Section 3 against federal office holders and candidates. Granting the states that authority would invert the 14th Amendment's rebalancing of federal and state power. Here I'll interject and say, however, there has been no congressional legislation that has been put into place for the enforcement of Section 3. And since Section 3 deals specifically with conduct that would disqualify them from elected office, it necessarily falls within the bounds of the elections and the electors clauses, because that gives the states the power. And absent congressional enforcement authority of Section 3, states would fill in that place. But if states were free to, now the court says, but if the states were free to enforce Section 3 by barring candidates from running in the first place, Congress would be forced to exercise its disability removal power before voting begins if it wished for its decision to have any effect on the current election cycle. Perhaps a state may burden congressional authority in such a way when it exercises its exclusive sovereign power over its own state offices, but it is implausible to suppose that the Constitution affirmatively delegated to states the authority to impose such a burden on congressional power with respect to candidates for federal office. Here again makes this distinction that the amendment itself doesn't make, reads it into the amendment. So this ruling reads into the amendment the distinction made that this court is making, that the amendment itself didn't make, despite the fact that its overarching principle may have been to restrict state power. Remember, it's Section 1 of the 14th Amendment is self-executing as well. And this court's argument for that is, well, those are, vesting rights on the people, not taking away of a right. So every argument has a counter argument, and the court makes best use of that. Nor have the respondents identified any tradition of state enforcement of Section 3 against federal office holders or candidates in the years following ratification of the 14th Amendment. Such a lack of historical precedent is generally a telling indication of a severe constitutional problem with the asserted power, or that there has never been an instance where there has been a federal official who has taken an oath and then rebelled and engaged in insurrection. That's the more it. We don't have the tradition because we haven't had an insurrectionist former president. States did disqualify persons from holding state offices following ratification of the 14th Amendment. That pattern of disqualification with respect to state but not federal offices provides persuasive evidence of a general understanding that the states lacked enforcement power with respect to the latter, or the truth that there has never been somebody vying for federal office who has been found by a fact-finding court to have engaged in insurrection. That hasn't happened, but this court doesn't talk about that. Shortly after ratifying of the amendment, Congress enacted Enforcement Act of 1870. That act authorized federal district attorneys to bring civil actions in federal court to remove anyone holding non-legislative office, federal or state, in violation of Section 3, and made holding or attempting to hold office in violation of Section 3 a federal crime. Mind you, that was repealed in 1948. In the years following ratification, the House and Senate exercised their unique powers under Article 1 to adjudicate challenges contending that certain prospective or sitting members could not take or retain their seats due to Section 3. And the Confiscation Act of 1862, which predated Section 3, effectively provided an additional procedure for enforcing disqualification. That law made engaging in insurrection or rebellion, among other acts, a federal crime punishable by disqualification from holding office under the United States. A successor of those provisions remains on the books today. See 18 U.S.C. 2383, insurrection or rebellion. So here the court leans on the Enforcement Act, and it sort of skims over and doesn't address the fact that there is no current law. The only current law that is there is insufficient for the civil procedure that the Enforcement Act of 1870 provided for, which was the disqualification process as prescribed in Section 3. 18 USC 2383 doesn't have that because it doesn't have the remedy of Congress removing the disability. So, how could that be compatible? But we don't hear this court talk about that. Um, Let me have a drink of water. If you are here, thank you so much for being here. And I know it's not a good day when one has to uh, see that somebody who clearly, by our eyes, engaged in insurrection is not being disqualified by the highest court. And the highest court is jumping and looping and finding different reasons and reasonings to uh, skip out on holding this person liable for engaging in insurrection. It's creating precedent. This Supreme Court is not only activist, it's radical in that sense. Going back to the opinion, Section 3, unlike other provisions of the 14th Amendment, prescribes conduct of individuals. So here it's making the distinction of why it's not self enforcing. It bars persons from holding office after taking qualifying oath and then engaging in insurrection or rebellion. Nothing more. Any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870 and 18 USC 2383, reflect congruence and proportionality between preventing or remedying that conduct and the means adopted to do that end. Neither we nor respondents are aware of any other legislation by Congress to enforce Section 3. So the court says that's what needs to happen, but there's no uh, congressional act on this matter. And in the absence of it, in the context of elections, states do have the power under Article 2. And but this court thinks, I mean, it creates precedent and becomes an activist court and sort of tramples on the Constitution. But the notion that the Constitution grants states freer rein than Congress to decide how Section 3 should be enforced with respect to federal offices is simply implausible, and doesn't say why it's implausible, but it's just implausible. Not even, really explaining it why. Finally, state enforcement of Section 3 with respect to presidency would raise heightened concerns. In the context of a presidential election, state imposed restrictions implicate a unique, important national interest. But state by state resolution of the question whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represent all voters in the nation. Conflicting state outcomes concerning the same condition could reflect not just from differing views of merits, but from variations in state law governing the proceedings that are necessary that make Section 3 disqualification determinations. Some states might allow Section 3 challenge to succeed based on preponderance of the evidence, while others might require heightened showing. Indeed, in some states, unlike in Colorado and Maine, procedures for excluding an ineligible candidate from the ballot may not exist. The patchwork that would likely result from this state enforcement would sever the direct link that framers found so critical between the national government and the people of the United States as a whole. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. The disruption would be all the more acute if Section 3 enforcement were attempted after the nation has voted. because states, if you were to give states the latitude to decide when, nothing in the Constitution requires that we endure such a chaos, arriving at any time or different times up to and perhaps beyond the inauguration. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of the Colorado Supreme Court, therefore, cannot stand. So, it's a 13-page opinion. You would think that the Supreme Court would want to write more about so much that they have just given, that it is up to Congress, and Congress has this power. States do not have this power. The distinction between state officers and federal officers, these things were not part of the question. Part of the question was whether Colorado erred or not, and the rationale that the concurring opinions of the three liberal justices and Justice Amy Coney Barrett point out is that the court goes much further than it should have. It becomes an activist court. And in Amy Coney Barrett's short concurrence, it says, I agree that states lack power to enforce Section 3 against presidential candidates. That principle is sufficient to resolve this case, and I would decide no more than that. So it does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. So all the going into what states can do and what it cannot do, all those things were created by this court for this ruling, in a very short 13-page ruling. Then in concurrence of Justice Sotomayor, Justice Kagan, and Justice Jackson, if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. And that is the first thing that this concurrence starts with, which was part of the Dobbs decision, which took away the right of a woman's right to choose. If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. But in this case, it does. Today, the court departs from that vital principle, deciding not just this case, but challenges that might arise in the future. Allowing Colorado to do so, we agree, would create a chaotic state-by-state patchwork to disqualify presidential candidate at odds with our nation's federalism principles. That is enough to resolve this case. But this court decides novel constitutional questions to insulate this court and petitioner from future controversy. The majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily and therefore concur only in the judgment. Our Constitution leaves some questions to the states while committing others to the federal government. Federalism principles embedded in that constitutional structure decide this case. States cannot use their control over the ballot to undermine the national government. Section 3 marked the first time the Constitution placed substantive limits on a state's authority to choose its own officials. Given that context, it would defy logic for Section 3 to give states new powers to determine who may hold the presidency. And here I believe, even this concurrence slips up because it doesn't talk about this specific case, how the states have power under the Elections and Electors Clause, and how that power goes to the states specifically in the context of Section 3, because there is no congressional legislation, as the court concedes, to enforce Section 3, with the exception of 18 USC 2383, which is not sufficient. That provides a secure and sufficient basis to resolve this case. To allow Colorado to take a presidential candidate off the ballot under Section 3 would imperil the framers' vision of a federal government directly responsible to the people. Again, going to precedent term limits. The court should have started and ended its opinion with this conclusion. Yet the court continues on to resolve questions not before us. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed, therefore telling the legislator what to do, as opposed to interpreting the law. It's what activists and radicalized courts do, not conservative courts. To start, nothing in Section 3's text supports the majority's view of how federal disqualification efforts must operate. Section 3 states simply that no person shall hold certain positions and offices if they are oath-breaking insurrectionists. Nothing in that unequivocal bar suggests that implementing legislation enacted under Section 5 is critical. Similarly, nothing else in the rest of the 14th Amendment supports the majority's view. Section 5 gives Congress the power to enforce the amendment by appropriate legislation. Remedial legislation of any kind, however, is not required. All the Reconstruction amendments, including the Due Process Clause and equal protection guarantees and prohibition of slavery, are self-executing, meaning they do not depend on legislation. Similarly, other constitutional rules of disqualification, like the two-term limit of the presidency, do not require implementing legislation, nor does the majority suggest otherwise. It simply creates a special rule for the insurrection disability in Section 3. The majority is left with next to no support for its requirement that a Section 3 disqualification can occur only pursuant to legislation enacted for that purpose. It cites Griffin's case, but that is a non-precedential lower court opinion by a single justice in his capacity as a circuit judge. Ultimately, under the guise of providing a more complete explanation for the judgment, the majority resolves many unsettled questions about Section 3. It forecloses judicial enforcement of that provision, such as might occur when a party is prosecuted by an insurrectionist, and it raises a defense on that score. The majority further holds that any legislation to enforce this provision must prescribe certain procedures tailored to Section 3, ruling out enforcement under general federal statutes requiring the government to comply with the law. By resolving these and other questions, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal office. The court needed today to resolve only a single question: whether an individual state may keep a presidential candidate found to have engaged in insurrection off its ballots. The majority resolves much more than the case before us. In a sensitive case crying out for judicial restraint, it abandons that course. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. So you can tell that it's a forceful concurrence where three liberal justices and Justice Amy Coney Barrett are coming out and saying that the majority has been an activist court by going far beyond the question presented and adjudicating far beyond uh, the question presented and done and the concurring opinion of uh, Justice Sotomayor, Kagan, and Jackson points out that they did much more than they should have by effectively saying exactly what Congress needs to do. When Congress already did it over 150 years ago, then repealed it about 80 years ago, and then there's nothing in the books about it. So, you know, instead of having a 13-page opinion, the court should have explained why did Congress repeal? Why did it go between 1948 and now that the only law that exists is a successor to a 1862 law that is rebellion and insurrection, which is now in the books, which doesn't provide the remedy of uh, 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 removing the disability by Congress. So it's an incongruous ruling. I believe in the long run, this ruling will be looked at disfavorably by the Supreme Court itself once its composition changes. It may take time, which means decades, but this is an activist ruling that spells into the amendment things that are not there. And that's why I believe it's a weak ruling, even though the justices concur with the final ruling and therefore it becomes 9-0. It really is a 5-4 ruling because the justices who concurred went along with the end judgment, but not the method that the Supreme Court took, the majority of 5 took, in shaping how Section 3 needs to be looked at by Congress. That's Congress's job. And Congress didn't do anything. So the question of the Supreme Court should have been, why hasn't Congress done anything? And absent Congress's doing anything, who has the power? That should have been the question. But that's not the question that this court resolved. And it's a disappointing opinion. So I don't see any questions. That's the end of today's session. Thank you so much for being here. Please like and subscribe if you are new to my channel, and share. And if you just arrived, you can scroll on back about 40 minutes. What I did was read out the opinion by the Supreme Court that allows Donald Trump to remain on election ballots and says that Section 3 of the 14th Amendment cannot be applied by the states to disqualify somebody from federal office. So with that said, thank you so much. And I will come out and talk to you soon. I'll talk to you soon about immunity, and I will post out some videos from the DC Circuit Court's ruling on immunity. Mind you, disqualification and immunity are completely different, not related. And I want to bring up immunity because that's what's before the court in the next couple of months. And I already did a video on it, on the question presented, and I'll break it down further in the next couple of weeks. With that said, take care.